Indiana insurance adjusters love to use a lazy formula called the multiplier to settle brain injury cases. They take you past medical bills, multiply them by 2 or 3, and tell you that's all the pain and suffering is worth. If you fall for this trap before calculating your future neurocognitive therapy costs, you will run out of money long before your brain finishes healing. Economic damages are the objective, verifiable financial losses. These are the things we can prove with a receipt, an invoice, or a line item bill. They include your past medical bills, your lost wages from missing work at your job, and any sort of out-of-pocket expenses. Non-economic damages are the subjective human losses. This is what the law calls pain and suffering, mental anguish, loss of enjoyment of life, and the destruction of your daily routines. In a brain injury case, the non-economic damages are almost always the largest component of true value because a brain injury changes who you are. Many people make the fatal mistake of trying to settle their case while they are still treating. In Indiana, once you sign a release and take a settlement check, your case is closed forever. If you find out 2 years from now that you need advanced cognitive rehabilitation, you cannot go back and ask for more money. Calculating future medical care for a brain injury requires specialized medical experts. We frequently work with neuropsychologists, neurologists, and life care planners to map out exactly what your medical needs look like for the next 10, 20, or 30 years. Future care for a significant brain injury rarely means just taking a pill. It involves extensive neurocognitive therapy. This is specialized rehabilitation designed to help retrain the pathways of your brain. It includes speech therapy, occupational therapy to manage daily tasks, vestibular rehabilitation to fix balance issues caused by inner ear, brain miscommunication, and psychological support to deal with the anxiety and depression that naturally flow from a TBI. When we calculate these costs, we don't just guess what they will be. We look at the localized cost of these specialized therapists right here in Indiana, calculate the exact frequency of visits required, factor in inflation, and build a comprehensive life care plan to protect your security. Insurance adjusters want you to believe that pain and suffering is calculated by a simple mathematical formula, multiplying your past medical bills by 2 or 3. This is the insurance trap. For a broken bone, a multiplier might occasionally get close. For a brain injury, it's a complete scam. A brain injury might result in relatively low initial medical bills if you didn't have surgery, but the catastrophic impact on your daily life, your career, and your marriage could be worth hundreds of thousands more than what any basic formula would ever generate. To establish the permanent nature of a brain injury in an Indiana personal injury lawsuit, we utilize a tool called a PPI rating, which stands for Permanent Partial Impairment. Once you've reached maximum medical improvement, or MMI, meaning your recovery has plateaued and your remaining symptoms are likely permanent, a qualified medical doctor or neurologist will evaluate you using the AMA guides to evaluation of permanent impairment. Let me show you a little picture of a brain here, and we're looking at it from the side view, and this is the frontal lobe here. When a doctor determines a PPI rating and that you've injured your frontal lobe, they aren't looking at a broken bone. They're looking at how your frontal lobe regulates your executive function, memory, and concentration. The doctor will assign a literal percentage rating to your impairment. For example, a 15% impairment rating of the whole body. In an Indiana court, a permanent impairment rating is a powerful piece of evidence. It tells the jury and the insurance company that a medical professional has verified that a portion of your brain function is gone forever, which directly derives both economic value of your future lost earning capacity and the non-economic value of your lifelong suffering. Let me share an Indiana law secret. The modified comparative fault reality, Indiana operates under this whole idea of modified comparative fault. This means if you are found more than 50% at fault for an accident, you recover zero. If you are 50% or less at fault, your recovery is reduced by your percentage of fault. Because brain injuries cause memory loss, the defense will often try to twist your confusion during a deposition to blame you for the crash. Securing immediate objective evidence and anchoring your medical deficits early prevents the defense from abusing your memory lapses to artificially inflate your percentage of fault. When it comes to proving your non-economic damages to an Indiana jury or a tough insurance defense lawyer, your own testimony is important, but it isn't the most powerful tool. The defense will always argue that you're exaggerating your memory problems or your irritability to get a bigger paycheck. They will even argue that your spouse or your parents are biased because they love you and want to see you win. The absolute strongest witnesses for non-economic damages are what we call before and after witnesses. These are people who have absolutely no financial claim or stake in your lawsuit. They are objective observers from your everyday life before the accident occurred. This includes coworkers or a prior boss who can describe how sharp-focused and organized you used to be on the job versus the struggles that you face now. People from your bowling league or your local softball team who can testify about your loss of coordination, balance, or your sudden inability to stay in loud environments. The friends you used to hunt or fish with, who can describe how you used to navigate the woods with ease, but now you get easily fatigued or confused. A neighbor or someone from your church community who can detail the visible differences that they have personally observed in your personality, your mood, and your physical interactions. When a regular Indiana citizen steps onto the witness stand and says, "I've known this person for 10 years. Before the crash, he was the life of the camp, sharp as a tack. Now when I see him, he stares blankly. He loses his train of thought mid-sentence, and he had to stop coming because the noise and focus are just too much for him." The insurance company's defense completely collapses. That is objective, undeniable proof of a ruined life. Right now, while your case is pending, do not rely on your memory to think of these people later. Take out a piece of paper and write down the names and phone numbers of 5 to 7 people who interacted with you regularly before the accident, but who are not related to you. Note down specific activities you used to do with them that you can no longer participate in or now have difficulty participating in. Hand this list to your attorney early so they can interview these vital before and after witnesses before the defense has a chance to corner them. Calculating the true settlement value of an Indiana brain injury claim is a complex medical and legal equation. You cannot let an insurance company reduce your life-altering injury down to a quick, cheap mathematical formula. You need a team that understands the advanced medicine, knows how to secure the right PPI ratings, and knows how to build an army of objective witnesses to tell your true story. Now that you understand how we calculate the full financial and human value of your brain injury claim, your next crucial step is learning how to protect that value during the litigation process yourself. You need to watch my next video right here, Proving Your Hidden Brain Injury to a Jury. In that video, I'm going to show you the exact strategies, tests, and witnesses that you can use to prove your case to a jury. I'll see you over there.